Honourable Nanaia Mahuta.
I'm pleased to be able to take a brief call at the first reading of this bill. I want to mihi to all the iwi who have been identified as members of this collective redress. And I want to more specifically go to some of the detail of the bill that I'll be raising in the Select Committee, because at the end of the day, our role as the Māori Affairs Select Committee will be to put under some scrutiny the ambitions of the deed and the aspects of how the legislation relates to that. So firstly, I do want to question officials further around the issues of how the co-governance model operates and what the relationship of that body will be with regards to the Auckland Council, the super city. Because one would consider that if all the volcanic cones, all the maunga, are managed in a collective way for the to be able to reflect in part the relationship of those iwi with those maunga, but for the greater purposes of public use, then you would want to know that there is a deliberate connect with ATED, for example, in Auckland, because they're there to promote Auckland as a super city. They're there to ensure that the tourism, the natural features and those aspects can be achieved in a very comprehensive way. And I just want to ask, well, is there a formal relationship of the co-governance group with the way in which ATED develop its plans and its aspirations for improving tourism in the isthmus? Secondly, and more specifically, is in relation to Part 4 and Schedule 5 of the bill, all the provisions around the rights of first rights of refusal. Now, there are quite specific. There's a level of detail around the timeframes for which rights of first refusal provisions can take place, a 40-day period roughly. And if hindsight is anything to go by, this whole mechanism is still a bit clunky. I can say that from certainly our iwi's perspective, is the way in which the first rights of refusal mechanism operates doesn't operate as smoothly as it could and should be reviewed as a matter of course. So I want to pursue in more detail how these provisions apply, if they will actually achieve what they're intended to achieve, and whether the timeframes are realistic in terms of enabling a transfer. Also, there are a number of Crown lands that are identified that can be transferred at some point or another to respective iwi or some authorities. And I would like to pursue whether or not it's an all-in or some-in type of approach of the Crown assets. So I'm sure officials will be able to help, certainly my thinking and clarity in that respect. I am aware that certainly iwi with Waikato connections are pursuing their individual and specific claims, and I want to in some part commend Michael Drever for starting with where people can agree, realising the huge task before him, which is then going to the more specific. And I only need to point out the Waikato iwi who are included here: Tamoho, Te Aki Tai, Te Kawerau Maki, Ngāti Te Ata, and Ngaitai ki Tamaki. These will all have very distinct interests within the isthmus. Boundary issues will be a challenge to work that out, and more specifically, because it is the Auckland Isthmus, there will be a fusing, I think, of some historical claims with some contemporary claims. So how the approach to that will take place going forward, although it's not under the direct purview of this particular bill, it is of some interest, I would expect, to the members of the Māori Affairs Select Committee as to how there will be scope for those individual iwi to be able to achieve their specific claims. And we should pursue this with a level of vigour that enables a good, healthy opportunity for specific claims to be able to leverage off what is in here. For example, the transfer of first rights of refusal lands to more specific and identified iwi, I think, might be one area where there is crossover. Mr. Speaker, I have grown up for some of my life in Auckland. I was born there, and certainly until I was about 5, got towed around by my parents to all sorts of places. We spent a lot of time in Mangere, by Mangere Mountain, at old Bob Kerr's place, who used to then be at the university where my father was studying. But we learnt a lot about the history in that part of Auckland, and certainly in Ngāti Te Ata's footprint around Mātukutereia, around the stone fields there, Te Aki Tai, Pukaki, and around the airport. So I have some affinity to the needs to ensure that the boundary issues are relatively well sorted out here. Growing up as a young child and having the honour of listening to some of the old people that I can recollect in that time, they were very clear about whose interests were within Tamaki. Now it's been kind of fused together. But naming is an important thing, and I want to pick up on the point raised by both Reno and Te Ururoa and Shane, is that if we have nothing else as Māori to I guess, stake our claim, naming becomes very important. And who can whakapapa to the names in Arohe will often tell you who has mana whenua status. Now, without throwing all the balls in the air here on this issue, I thought it was interesting too that some of the maunga didn't have the Māori names set out, and again, this would be a question for officials, and perhaps it may be clarified in the submissions as to why this didn't take place. But it is of certain note that this type of omission has taken place. Another point to raise is that is really to paraphrase again what the Minister said. This bill doesn't address all the historical claims in the issue, in the isthmus, and it doesn't provide the level of redress that this House has been used to when debating treaty settlements. However, it does provide scope, and it provides scope for a collective of iwi in a significant city, in the biggest city of New Zealand, to find a way of working together around some common interests. And for that, I commend OTS, I commend the Minister, and I commend Michael Drever and his team for bringing this bill to the House. Now, I was at the signing for the bill, and I heard all the side stories. But what I was more interested in was that people had the fortitude and the foresight to be able to identify the things that they can agree on. And in this day and age, and certainly in Auckland, and certainly with regards to the way in which treaty settlements are quickly evolving, I think this will provide a good lot of scope, certainly in the area of tourism, and certainly in the area of preservation of natural features within the Tamaki Isthmus, to be protected, to be utilised, to be able to be enhanced, and also to leverage what Auckland City has to offer to many people who are visiting and living in the city. So again, I'm looking forward to the bill coming to the Select Committee. I'm looking forward to the submissions. I hope we have a robust number of submissions that can clarify some of the questions that are swirling around and have been presented to the House today. And when it comes to the second reading speech, perhaps I'll be in a position where I can answer some of the questions that I've brought to the House today. Tēnā koutou.
I call the Honourable Member Sam.